With the help of this video, one can prepare for Railway Departmental Examination and other railway competitive examinations. Indian Railway Establishment's Rules and Labour Laws. Disciplinary and Appeal Rules, 1968. Procedure for imposing major penalties. 1. No order imposing of any of the penalties specified in clauses V to X of Rule 6, major penalties, shall be made except after an inquiry held, as far as may be, in the manner provided by the Public Servants, Inquiries, Act, 1850, 37 of 1850, where such inquiry is held under that Act. 2. The disciplinary authority shall frame charge sheet and deliver or cause to be delivered to the railway servant a copy of the articles of charges, the statement of the imputation of misconduct or misbehaviour and a list of documents and witnesses by which each article of charge is proposed to be sustained, and shall require the railway servant to submit a written statement of his defence within 10 days or such further time as the disciplinary authority may allow. 3. The railway servant may, for the purpose of his defence, submit with the written statement of his defence, a list of witnesses to be examined. The authority shall furnish him with a copy each of such statement as early as possible, and in case not later than 3 days before the commencement of the examination of the witness. The enquiring authority may, for reasons to be recorded by it in writing, refuse to permit such of the documents as are, in its opinion, not relevant to the case, or it would be against public interest or security of the state. On receipt of the written statement of defense, the disciplinary authority, if decides to proceed with the inquiry, it may itself inquire into such of the article of charges as are not admitted, or appoint a board of inquiry or an inquiry officer for the purpose of inquiry. 4. Where the disciplinary authority itself inquires into the article of charge, or appoint a board of inquiry or any other inquiring authority for holding an inquiry into such charge, it may, by an order in writing, appoint a railway or any other government servant to be known as presenting officer to present on its behalf the case in support of the article of charge. For arranging a presenting officer from CB1. In the following type of cases reference may be made to Railway Board. A. Cases in which outsider have to be produced as prosecution witnesses. B. Cases of disproportionate assets. C. CBI trap cases. The railway servant may also present his case with the assistance of any other railway servant, including railway servant on leave preparatory to retirement, retired railway servant, and an official of a railway trade unions recognized by the railway administration but not a legal practitioner, employed on the same railway. The union official shall not be allowed to appear in a disciplinary case unless he has worked in recognized union for a period of at least 1 year. 5. On the fixed date for inquiry, the oral and documentary evidence by which the articles of charge are proposed to be proved, shall be produced by the disciplinary authority. The witnesses shall be examined by the presenting officer, if any, and may be cross-examined by or on behalf of the railway servant. The presenting officer, if any, shall be entitled to re-examine the witnesses on any points on which they have been cross-examined, but on any new matter only with the leave of the inquiring authority. The inquiring authority may also put such questions to witnesses as it thinks fit. 6. When the case for the disciplinary authority is closed, the railway servant shall be required to state his defense orally, or in writing, as he may prefer. The witnesses produced by railway servant shall then be examined by or behalf of him, and shall be cross-examined by presenting officer, if any. The railway servant shall be entitled to re-examine the witnesses on any point on which they have been cross-examined, but not on any new matter, without the leave of inquiring officer. 7. The inquiring authority may, after the completion of the production of evidence, hear the presenting officer, if any, and the railway servant, or permit them to file written briefs of their respective cases, if they so desire. After the conclusion of the inquiry, a report shall be prepared by the inquiring authority. Taking into consideration the report, if the disciplinary authority is of opinion that any of the penalties specified in clauses V to X of Rule 6, major penalties, should be imposed on railway servant, it shall make an order imposing such penalty, and it shall not be necessary to give the railway servant any opportunity of making representation. 8. The orders made by the disciplinary authority shall be communicated to railway servant, who shall also be supplied with a copy of report of inquiry and a copy of its finding of the disciplinary authority, together with brief reasons for its disagreement, if any, with the findings of the inquiring authority.